A thread by Brian Cates on the recent filing from Sidney Powell on behalf of General Flynn against Judge Emmett Sullivan's request for an en banc review from the Circuit Court. Brian begins, I got a feeling before much longer, both me and Sidney Powell are going to learn at last the reason why Judge Contreras was removed from this case. From the Powell filing, point 2, the plea proceeding conducted by Judge Contreras is void. Judge Contreras was recused almost immediately for reasons long known to the government, but not to Flynn. Quote from Ri al-Nashiri. If a judge should have been recused from the proceedings, then any work produced by that judge must also be recused, that is, suppressed. Brian continues, the only injury Judge Sullivan has suffered here is that he likely told his DC inside the Beltway clique that he was really looking forward to sending General Flynn to prison. And he's upset because now he's not going to be able to, which is why we got this 10 weeks circus. From the Sidney Powell filing, Judge Sullivan has no standing to litigate. No rule or precedent authorizes a district judge to seek rehearing of a mandamus order. A district court ordered to respond to a petition for a writ of mandamus is not thereby endowed with the rights of a party. The resulting mandamus from this court to Judge Sullivan, just like any appellate order to a district court, does not give the judge standing to litigate issues as a party, intervener, or amicus, Ligon versus City of New York. The irreducible constitutional minimum of standing contains 3 elements, the first of which is an injury in fact that is concrete and particularized and actual and imminent. Judge Sullivan, the supposed umpire, does not make it to first base. He has no injury. Brian continues. From Sidney Powell's filing, or in lay terms, umpires don't get to swing bats or run bases. They suffer no harm when one team wins and the other loses. Likewise, this court's order to grant dismissal was not an injury to Judge Sullivan, who, if he does have a personal stake in the outcome of the case, would be disqualified and required to remove himself immediately. Brian responds, correct. Sullivan keeps acting like he has some kind of personal stake in the outcome of this case. If he does, that's grounds for a recusal right there. From the Sidney Powell filing, it is Judge Sullivan who is disrupting the orderly administration of justice. Not only does the law require him to have granted the government's substantial motion with no fuss, but he should have also granted General Flynn's 2 motions opposing amicus. ECF numbers 201, 204. He had 6 more days to consider before General Flynn petitioned for mandamus. Judge Sullivan also should have ordered dismissal promptly upon receipt of the court's opinion. Instead, he waited another 15 days to file an improper petition for rehearing. As Ligon quoted from the Ninth Circuit, quote, in the scheme of the federal judicial system, the district court is required to follow and implement our decisions, just as we are oath and duty bound to follow the decisions and mandates of the United States Supreme Court. Brian responds, I see no way that 6 of these 11 judges on the DC Court of Appeals agree to let Sullivan drag this on any longer. Powell is obliterating Sullivan in this filing.